Welcome to this session on employees' legal rights and responsibilities. In this training, we will follow the slides closely and present each topic in clear, practical terms. By the end of this training, participants will have knowledge of workplace occupational health and safety and a clear understanding of employees' legal rights and responsibilities. After completing this program, you will be able to identify QHS issues, explain employee rights, and describe employee responsibilities related to safety and compliance. We will reference the hierarchy of legislation, Constitution of the Republic of Turkey, laws, decrees with the force of law, regulations, and notices, each layer guiding obligations in the workplace. This section introduces general information on OHS, highlights the legislation that regulates working life, and frames the legal rights and responsibilities that apply to all parties. OHS is a shared structure. The government sets rules, organizes inspections, and enforces compliance. The employer identifies legal measures, conducts risk analysis, implements and monitors controls, ensures participation, provides training and information, appoints an OHS expert, and coordinates the workplace health and safety unit. Employees must comply with legislation and workplace rules, take part in OHS activities, inspections, and training, use machinery, equipment, and PPE as instructed, and report OHS deficiencies to the employer, requesting necessary measures. Under Law Number 6331, the employer ensures OHS by taking all necessary measures, preventing risks, providing training and information, arranging the workplace accordingly, supplying required equipment and tools, adapting to changing conditions, and improving current practices. The employer monitors and audits compliance, eliminates nonconformities, conducts or has conducted risk assessments, assigns tasks considering each employee's suitability for health and safety, and prevents uninstructed personnel from entering life-threatening or special hazard areas. To sustain OHS, the employer informs employees and representatives about workplace risks and the protective/preventive measures, their legal rights and responsibilities, and the persons assigned to first aid, emergencies, disaster response, firefighting, and evacuation. Employers must obtain employees' opinions and ensure participation on OHS matters, recognizing their right to propose and join discussions, and consulting them on the impact of new technologies, equipment choices, and work environment conditions on health and safety. Employees must not endanger their own health and safety or that of others. In line with training and instructions, they must use machinery and tools correctly, use PPE properly, and avoid removing or altering safety devices without authorization. In line with the training and instructions provided by the employer, employees must fulfill several key responsibilities. They are required to use machinery, equipment, tools, hazardous materials, and transportation systems strictly according to established rules. Safety equipment provided in the workplace must always be used correctly, and employees must never remove or alter them without authorization. Additionally, all personal protective equipment must be properly worn, maintained, and preserved, ensuring both personal safety and the safety of colleagues. Employees also have the duty to immediately notify the employer or an employee representative whenever they encounter serious or imminent health and safety hazards. This includes dangers arising from machinery, tools, equipment, facilities, or workplace structures, as well as deficiencies in protective measures. Furthermore, employees must actively cooperate with the employer and employee representatives to correct deficiencies and ensure compliance with legal regulations identified during inspections. Collaboration is not optional but an essential part of maintaining overall workplace safety. If an employee faces a serious and imminent danger, they have the legal right to refuse work. In such cases, the employee may apply to the Occupational Health and Safety Committee or directly to the employer if no committee exists to evaluate the situation. The committee is obliged to convene without delay, and the employer must make a decision immediately. This process must be documented in a written report, which is then communicated both to the employee and to the employee representative. If the committee or employer confirms the employee's request, the employee may refrain from work until the necessary precautions are taken. During this period, the employee's wages and all rights under the law and employment contract remain protected. This ensures that workers are not penalized for prioritizing their health and safety, and it reinforces the principle that safety always takes precedence over production. According to Occupational Health and Safety Law No. 6331, the employer has a comprehensive set of obligations. These include taking every necessary measure to prevent occupational risks, providing ongoing training and information, and ensuring that safety practices adapt to evolving workplace conditions. Employers must also supply the required equipment, organize work safely, and continuously improve safety standards. Importantly, risk assessments must be conducted, compliance must be monitored, and nonconformities must be corrected immediately. Tasks should be assigned only after verifying the employee's suitability in terms of health and safety. Employees who lack sufficient knowledge or training must not be allowed into hazardous areas under any circumstances. Law number 6331 also clearly defines employee responsibilities. Employees must avoid actions that endanger their own health and safety or that of others. This includes correctly using all machinery, tools, hazardous materials, and protective equipment provided by the employer. Personal protective equipment must be worn and maintained properly at all times. Employees are also obligated to immediately report any serious health and safety threats or deficiencies to the employer or employee representative. Lastly, they must cooperate fully in correcting deficiencies identified by inspection authorities and work jointly with the employer to maintain a safe working environment. Occupational health and safety is a shared responsibility involving the government, the employer, and the employees. The government establishes regulations, creates infrastructure, and ensures enforcement. Employers are responsible for eliminating unsafe conditions, training employees, providing necessary equipment, and auditing compliance with safety measures. Employees, on the other hand, must comply with all safety precautions and contribute to maintaining a secure workplace. Several regulations form the legal backbone of occupational health and safety. These include the Occupational Health and Safety Regulation, the Occupational Health and Safety Services Regulation, and regulations specifying the duties and qualifications of occupational safety experts and occupational physicians. Other key regulations cover the functioning of occupational health and safety committees, the procedures for risk assessments, rules for employee safety training, workplace safety signage, and the mandatory use of personal protective equipment. Additional regulations detail safety requirements in specific workplace contexts. These include measures for workplace buildings, rules for manual handling operations, and guidelines for work involving hazardous chemicals. Noise exposure standards are also regulated, alongside specific protections for female employees working night shifts and for workers on rotating shifts. Moreover, rules exist for the safe use of display screen equipment and for ensuring that all work equipment used in the workplace meets established health and safety standards. According to the Constitution, work is recognized as both a right and a duty for every individual. Article 50 explicitly prohibits employment that is incompatible with a person's age, gender, or physical capacity. Furthermore, minors, women, and individuals with physical or mental disabilities are provided with special legal protection regarding working conditions. Rest periods are also safeguarded as a constitutional right, including paid weekly rest, paid public holidays, and paid annual leave, all regulated by law. Labor Law number 4857 establishes the fundamental framework for employment relationships. It defines the employee as a real person working under an employment contract, while the employer may be an individual, a legal entity, or an unincorporated organization. The workplace is defined as the organizational unit where production is carried out through both material and immaterial resources. Those who act on behalf of the employer in directing the workplace and managing employees are referred to as employers' representatives. This law regulates the core aspects of employment rights and responsibilities in Turkey. Article 5 of the Labor Law emphasizes equality and prohibits discrimination in employment relationships. Employers may not discriminate based on language, race, gender, religion, political views, philosophical beliefs, or similar grounds. Moreover, part-time employees cannot be treated differently from full-time employees, and workers with fixed-term contracts cannot be disadvantaged compared to those with indefinite contracts, unless objective and valid reasons exist. This principle ensures fairness, equality, and respect for human dignity in the workplace. This article states that employees have the right to immediately terminate their employment contract under specific conditions. One of these is related to health reasons. If the nature of the job poses a serious danger to the employee's health or life, the employee may end the contract without waiting for the notice period. Additionally, if the employer or another worker with whom the employee is in constant and direct contact contracts an infectious disease or a condition incompatible with the employee's work, the employee may also choose to leave immediately. This legal protection ensures that workers are not forced to risk their health or safety due to workplace conditions. Employees also have the right to terminate their contract if the employer violates ethical or good faith principles. For instance, if the employer misrepresents the terms of the contract or provides false information at the time of hiring, thereby deceiving the employee, this is considered just cause. Moreover, if the employer behaves in a way that insults the employee or their family, damages their honor and dignity, or engages in sexual harassment, the employee is legally entitled to immediate termination. The right of immediate termination also covers situations where the employer harasses, intimidates, or pressures the employee or their family into unlawful acts. If the employer commits a crime against the employee or their family that is punishable by imprisonment, this too is valid grounds. Similarly, if an employee is subjected to sexual harassment at work by another employee or even a third party, and the employer does not take the necessary action despite being informed, the employee can legally end the contract. Finally, if the employer fails to calculate or pay wages in line with the law or contract, this again constitutes just cause for termination. In addition to health and ethical reasons, employees may terminate their contracts due to compelling circumstances. If there are extraordinary conditions at the workplace that cause operations to be suspended for more than 1 week, the employee is entitled to end the contract. This rule ensures that workers are not left without security or forced to endure prolonged uncertainty during situations where work becomes impossible. The law also gives employers the right to terminate an employment contract immediately under certain conditions. For example, if an employee contracts a disease or suffers a disability due to their own fault, irregular lifestyle, or alcoholism, and this results in absence for 3 consecutive days or 5 days in 1 month, the employer has the right to terminate. This ensures that prolonged absence caused by the employee's own actions does not disrupt the functioning of the workplace. If an employee's illness is deemed incurable and their continued employment is considered unsafe by the health board, the employer may terminate the contract. Additionally, if at the time of hiring the employee misled the employer by providing false qualifications, conditions, or essential information, this constitutes grounds for immediate termination. These rules safeguard the employer against dishonesty and prevent workplace risks related to long-term health conditions. The employer may also terminate the contract in cases of misconduct. If an employee insults the honor or dignity of the employer or their family, or if they engage in sexual harassment towards another employee, this is just cause for dismissal. Furthermore, if an employee harasses the employer, their family, or another worker, or comes to the workplace under the influence of alcohol or drugs, or uses such substances during work hours, the employer is entitled to terminate the contract immediately. The law also covers violations of honesty and loyalty. If an employee abuses the trust of the employer, commits theft, or discloses trade secrets, the employer can terminate the contract. If the employee commits a crime in the workplace that carries a prison sentence of more than 7 days without suspension, this is also grounds for dismissal. Finally, unexcused absenteeism, such as missing 2 consecutive days, the day after a holiday, or 3 days in a month without valid reason, also allows the employer to act. Employers also have the right to terminate if an employee persistently refuses to carry out their duties despite reminders. If the employee's negligence or carelessness endangers workplace safety or causes significant damage to machinery, equipment, or property that cannot be compensated within 30 days' wages, this is also just cause. This provision ensures accountability and responsibility for maintaining workplace safety and protecting valuable assets. Employees who have completed at least 1 year of service, including the probation period, are entitled to annual paid leave. This right cannot be waived under any circumstances. The law ensures that every worker has the opportunity for rest and recovery, contributing to both their well-being and workplace productivity. Annual paid leave is a fundamental right of employees. The length of annual leave depends on the employee's years of service. Those who have worked between 1 and 5 years are entitled to 14 days of leave. Workers with more than 5 years but less than 15 years of service receive 20 days, while those with 15 years or more are entitled to 26 days. Additionally, employees younger than 18 or older than 50 must be given at least 20 days of leave regardless of service. These rules ensure fairness, taking into account both seniority and age. The law strictly prohibits employees from working in another paid job during their annual leave. If it is discovered that an employee has done so, the employer has the right to reclaim the wages paid for that leave period. This regulation reinforces the purpose of annual leave, which is to provide genuine rest rather than additional employment. In accordance with Article 63, the standard working hours are limited to a maximum of 45 hours per week. Unless otherwise agreed, this time is distributed equally among the working days of the week. However, by mutual agreement between the employer and the employee, the weekly working time may be arranged differently across the days of the week. The only restriction is that the daily working hours must never exceed 11 hours. Article 64 regulates compensatory work. In cases such as force majeure, workplace closures around national or general holidays, or where employees are given leave upon their request, normal working hours may be reduced or suspended. In such cases, the employer may require employees to make up for lost hours within a 2-month period. Importantly, these make-up hours are not considered overtime or extended hours. According to Article 68, employees must be provided with rest breaks depending on the length of their workday. For work lasting up to 4 hours, at least 15 minutes of rest is required. For work exceeding 4 hours, but not more than 7.5 hours, a 30-minute break must be given. Finally, for work longer than 7.5 hours, the rest period must be at least 1 full hour. These breaks are essential for protecting the health and productivity of employees. Rest breaks outlined in labor law are minimum requirements and must be given without interruption. Depending on operational needs, these breaks can be scheduled for workers at the same or at different times. Importantly, these intermissions are not included within the calculation of actual working hours. Article 69 defines the night period at the workplace as beginning no later than 8 p.m. and ending no earlier than 6 a.m., lasting no more than 11 hours. Employees working during this period must not exceed 7.5 hours of night work. Before assigning employees to night shifts, employers must ensure that each worker undergoes a medical examination certifying their fitness for night work. Furthermore, employees working at night are required to have periodic health checks, conducted at least once every 2 years. Article 74 protects female employees during maternity. Women cannot be required to work for a total of 16 weeks, divided as 8 weeks before childbirth and 8 weeks afterward. In the case of multiple pregnancies, an additional 2 weeks is added to the pre-birth period. However, if the worker chooses and her health allows, she may work until 3 weeks before childbirth with a doctor's approval. In such cases, the weeks worked are added to the postpartum period, ensuring the total protective leave remains the same. Under Article 25, if an employee persistently refuses to perform assigned duties despite reminders, or if through negligence or intent they endanger workplace safety or cause damage to equipment beyond what can be compensated with 30 days' wages, the employer has the right to terminate the employment contract without compensation. This emphasizes accountability and reinforces safety standards in the workplace. According to Law Number 6331 on occupational health and safety, a workplace accident is an event occurring at work or as a result of work activities that causes death or leads to physical or mental impairment. Similarly, under Social Insurance Law No. 5510, an accident causing harm to the insured person is defined as a work accident. In essence, these are unplanned incidents that can result in injury, equipment damage, and interruption of production. Work-related accidents include several situations. Accidents occurring while the insured is at the workplace. The incidents during independent work on behalf of the employer. See accidents when the insured is sent outside the workplace on official duty. The accidents when a female worker is breastfeeding during her legally allocated time. The accidents occurring during commutes provided by the employer. All of these are recognized as occupational accidents under the law. Criminal responsibility is also tied to workplace safety. When an accident is the result of deliberate intent, it is considered a crime of intent. When it arises from knowledge but without the desired harmful result, it is a negligent crime. Workplace accidents, including domestic or traffic-related incidents tied to employment, are generally treated as negligent crimes. Such cases may lead to criminal proceedings against responsible parties. Negligent crimes in the context of occupational safety may arise from several causes. A negligence, B. Carelessness. C. Professional incompetence. D. Acts in violation of laws, regulations, or instructions. These are situations where the worker or employer fails to uphold safety standards, resulting in harm. The law classifies them as negligent crimes, ensuring accountability in occupational incidents. If an insured person suffers an occupational accident, contracts an occupational disease, or becomes ill as a result of an intentional act, they are not entitled to temporary disability benefits and similar income. In such cases, the person shall only be provided with necessary medical assistance. A near miss is an event that, by a hair's breadth, does not result in injury, illness, or damage. Near misses must be treated like accidents. The underlying factors should be investigated, and the nonconformities identified must be eliminated to prevent serious accidents in the future. If an accident occurs, report it to the security department. If there are injuries, make an emergency call. Secure the area. If you are trained, intervene appropriately.